Hello, thank you for joining us. I'm Dr. Derek Cohen, Director of Right on Crime here at the Texas Public Policy Foundation. And while it is April Fool's, the issue we'll be discussing today is one of critical importance, the setting of bail. Bail originated as a security for the reappearance of someone released during the pendency of their trial, and it has since evolved into a moving target trying to balance competing abstract ideals of liberty, innocence until proven guilty, and public safety. Litigation in Harris County, Dallas, and elsewhere has sidelined the efficient though flawed practice of using bail schedules to process high volumes and has since been replaced with what many argue is an over-reliance on personal bond, even for repeat offenders. To date, the Houston Crime Stoppers have identified over 100 murder victims over the past few years, slain at the hands of those released while on bond. Conversely, Texas jails are currently holding over 4,000 individuals accused of a misdemeanor. Certainly, there's a better way to do this, and that's what we're hoping to discuss. So joining me today are my friend and colleague, Randy Petersen, senior researcher here at the Texas Public Policy Foundation. Mr. Petersen has spent 21 years in law enforcement and 3 years as a law enforcement academy instructor. My friend and former colleague, Greg Glod, also joins us. He worked at Right on Crime prior to his current role as the Senior Fellow for Criminal Justice at Americans for Prosperity. And so, guys, let's just dive right in. I want to start off with Greg. Greg, define what bail is, how it works, and why it's the focus of so many people at the moment.
No, certainly. Thanks for having me on here, Derek. So bail essentially is a financial condition that allows for an individual to be released prior to their trial. And so you get arrested, you go before a judge, they look at your offense, they may look at your criminal history, a couple other things, and say, well, this person committed a small misdemeanor. They don't seem to be a threat to public safety. They've never had a criminal charge in their lives. We can probably let them out without any financial conditions for their release, and they can just move forward, and they'll have to show up for their next court date. For other people, maybe you've committed a higher level misdemeanor, or state jail felony, or a lower level felony, and they look and say, okay, this person's had a little bit of run-ins with law enforcement in the past. They've committed a crime in their past. Maybe we need to give some sort of conditions to ensure that they reappear. And so they might give you a $1,000 bail or a $10,000 bail or something else along those lines. You have to pay it or you have to sit there pre-trial. If you cannot afford it, either you have to sit there pre-trial or there is bail bondsmen that will come in and say, we will essentially ensure this person's appearance. They'll pay us, 10%, sometimes 5%, depending on if it's a higher amount. And we'll essentially take care of that and give the rest to the court. And so you don't actually have to pay the full amount. So if you have a $100,000 bail, you have to pay 10%, $10,000 upfront to the bondsman. So the problem with somewhat of the current system, and not necessarily with bondsmen, I think that's a totally different story and something we can talk about for another day. But essentially the problem with this system is that bail was supposed to be a insurance that people reappear, because if you pay a certain amount of money or say, this is what your bond, if you don't come back, you forfeit it. So you don't get your money back. And so that's the incentive to come back to court. You need to get your money back and pay that through. However, it's become the primary factor in how people's either freedom or detention pre-trial has been determined in Texas and across the country. And so instead of, hey, this person's a risk to public safety, we should actually have them detained or have some sort of higher level bail, those individuals, if they can afford it, are getting out. And people that are at a lower risk that can't afford it are staying in. And so that's the major issue. We have high risk people that can't afford bail, that may be a public safety threat, may be a risk of flight, are able to buy their way out of jail, while others on the lower end are not allowed if they don't have the financial capabilities to do so. And that's not probably the best policy to have when we're looking at public safety. We do not want individuals being determined if they should be being held pre-trial based upon their financial ability to pay, rather than doing it by risk, which should be the primary indicator in any pre-trial determination that a judge is going to make. And so we kind of have this whole thing tilted. Like Derek said earlier, this was supposed to be somewhat of an insurance policy just on risk of flight, not about public safety. And it's kind of turned into a one-size-fits-all approach that, hey, this is the offense that you've done. This is your criminal history. All right, we'll give you $15,000. If you can afford it, I guess you're not a risk. And if you can't, then you are a risk. It doesn't really make sense from a logical standpoint. And that's probably why we've seen a lot of different really horrible cases come out where individuals that were high risk have been able to afford bail. They get out, they commit another offense while other people languish in jail that aren't that risk. And so that's really what we're looking at and striving for, to try to right size the pretrial system from Americans' prosperity standpoint.
Well, thank you for that, Greg. And I know I can speak for you and myself saying that we've probably watched enough TV where we have actually seen bail work its way into popular culture, say with, police bring somebody in and they say, well, I'll be back on the streets in 2 hours. So that actually sets up the question I want to go to Randy for. So Randy, as a law enforcement officer, the actual bail process dovetails a lot with the role of law enforcement as broadly construed. What does law enforcement think of bail, how it works currently, and where it could go?
Well, that's a great question, and your opening monologue touched on some of that, as did Greg's opening there. Anytime we're trying to find that proper tension between the legitimate interests of the government, which Greg pointed to two of them, right? The expectation that someone will return to court who's been arrested and charged with a crime, as well as the protection of community, right? A public safety issue. Those are the legitimate interests of the government. And finding that proper tension between the individual rights, right? Remember, when we send somebody to pretrial detention, they haven't been convicted yet. And we have a standard in the United States that you are innocent until proven guilty. So detaining somebody prior to conviction is a big deal, right? And so trying to find that proper tension is always difficult. One of we like to use the word equal, right, or equality. But when you think about it, and Greg started to touch on this, there is nothing more unfair than being equal, right? If I get arrested, maybe $1,000 for me is a struggle, but I can do it, right? If somebody gets arrested and their only material possession is a sleeping bag, that $1,000 is not fair, right? It's equal, right? We both have $1,000 bond, committed the same crime, very different backgrounds, very different possibilities of showing up to court or public safety issues depending on our background, but it was equal, right? But it was completely unfair. The person who has no means to leave court may pose almost no danger and maybe would willingly show up to court, whereas you could have that $1,000 for a drug cartel member is really no incentive at all to show up to court. And I think not even arguably demonstrate pose a much greater threat to public safety. So from a law enforcement perspective, there's another thing that you consider, because police officers are not overly involved in bond issues, right? That's up to the courts and a lot of times set by statute and all of those things. But police departments, in particular sheriff's departments, they have to house the people who are being detained pre-trial at great cost to the community. So having the right people in there makes fiscal sense as well. And that bleeds over into local law enforcement too. Sometimes the sheriff's departments will have a policy that they're not going to hold misdemeanor pre-trial or pre-bond hearing detainees. So at least for a day or so, the police department has to house an individual if they're waiting to see a magistrate. So obviously, from a law enforcement perspective, looking at the genuine, legitimate interests of the government in this issue, public safety is a big issue. Returning to court is a big issue, but we can't tell that by having a broad, one-size-fits-all bond system, right? It has to be individualized. They have to be assessed for risk. There is no fairness in making everything just equal across the board. That doesn't help anyone.
And you hit on a very good point about somebody's access to means. And, just this week we supported legislation in the Texas Senate, SB 237 by Senator Betancourt, which actually confers citation authority on the police, whereas they were pretty much bound to arrest prior to. So it really allows the police officer to use his discretion to do the best course of action that protects the community, and also is probably also responsive to the accused as well. And that's just I think the common thread we're starting to see in a lot of this discussion is finding what increases flexibility, finding what puts the most amount of tools in the toolbox for the best outcome. And that dovetails nice into, Greg, you're an expert on this stuff nationally. You've seen reforms that have been passed that look good. You've seen reforms that have been passed that look bad, whether they're animated by, we'll say, well-meaning activists, I think I can say diplomatically, or the actual data surrounding it. Oftentimes those things do not overlap. What are we seeing nationally? What does the national landscape look like on the bail front?
Yeah, Derek, and like you said, it really is all over the place, and it's very jurisdictional. And so, I think one of the examples that we've seen of a place where good intentions, potentially bad results, was New York. And so New York really wanted to decrease their pretrial populations, ensure that lower risk individuals were able to be released, expeditiously, and to ensure that they weren't just languishing in jail pretrial, and ensure a mechanism that higher risk individuals were the focus of, jail beds. So essentially what they did was disallowed, and without any judicial discretion or prosecutorial discretion, for certain instant offenses, so what the person is actually being charged for, requires release regardless. And so what that does is hamstrings judges, it hamstrings prosecutors, it hamstrings the criminal justice system to not make an individual determination based upon the risk of the individual, just upon their instant offense. And so you could have someone that committed a low-level felony or a misdemeanor, and that instant offense is lower, but then you look at their track record of failing to appear multiple times in the last 2 years, or several convictions for higher level things. And those are individuals that may need either financial conditions of bail, other conditions like a GPS monitor or anything else like that, or to be detained pretrial. I mean, there's circumstances where we want people to be detained pretrial because of their threat to public safety, or they've shown and proven that they are a flight risk. And so the bill just said, regardless of that instant offense, you get to go out on a PR bond, a personal recognizance bond, nothing else. And so you saw very bad unintended consequences. You saw people literally churning in, getting arrested, being released, getting arrested, being released over and over again. Now, again, a lot of what was intended in there to allow for a mechanism for low-risk individuals to be released with minimal to no financial conditions is good. A mechanism to allow for higher-risk individuals to be detained, good. The problem was they divorced that release or detention from the actual risk of the individual. And that is where I think that bill kind of lost its track. And some of the other reforms that we've seen across the country kind of lost its track. Other jurisdictions such as Kentucky, West Virginia recently right now have essentially put in presumptions for those lower risks. So saying, hey, here's a risk assessment that has been objective, looking at someone's individual's criminal history and offense, if they fail to appear, putting that into an algorithm that's objective and evidence-based, and saying, okay, you are a lower risk person. We're going to presume that you could be potentially released here. And so Kentucky implemented this for a lot of misdemeanors and some lower level felonies, this presumption, and sometimes automatic for lower ones. And they've seen good results from that as well. And so I think we need to make sure of three goals when we're looking at something from a national standpoint. Allow for high risk individuals to be detained, allow for a mechanism for low risk individuals to be released expeditiously, and basing that on risk, albeit from a risk assessment or some other mechanism. And so I think some states like Kentucky, who have implemented a statewide risk assessment, have those presumptions within statute, is the right way to go, but then not going too far where you're handcuffing judges and prosecutors, similar to what happened in New York there. And so it's a really hard way to thread it, but I think those are the kind of the better ways to go about. And that's what we're kind of seeing around the country, across the board on pretrial.
So to underline that point, Greg, I know that here in Texas, we actually require, short of multiple serious felonies or an innocent offense of capital murder, that you are owed an actual bail amount and an opportunity to post it. And so how many other states have something like this or something, akin to this? And what's the alternative there? Does this require a constitutional amendment to get around?
Certainly. And so a lot of states do have within their constitutions a constitutional right to bail. Texas is much more rigid and narrow than almost any other state in the union that I have seen. There may be one, but I have not come across it. So like you said, in Texas, essentially, other than capital murder or multiple felony offenses in someone's past, someone enjoys the right to bail. And so they have to give an amount. And so we've seen this in multiple high level, high publicity murders where someone had to be given a bail amount. And in some of these, they couldn't afford it because they were very high. But what if that person can't afford it? Or a bondsman comes in and allows them to say, hey, if you put up 3%, you'll be able to be released here. Are we safer as a community? I don't think so. And so, yes, in Texas, I think it's going to require a constitutional amendment to change that mechanism and expand what those types of offenses are that could allow for bail to be denied, and actually have a pretrial detention system that looks at the person's risk rather than someone's instant offense, and expands what that could possibly be. There is a lot of other people that could potentially be a danger to the community that should be detained pre-trial, rather than someone that's committed capital murder or has multiple felony offenses in their past. I think that needs to be expanded. A constitutional amendment is probably necessary in Texas to expand that, and hopefully that is something that could come across the finish line here in the 2021 legislative session.
Can I sum up the instant offense issue that sometimes depraved heart felons trespass once in a while as well?
That is very astute, Dr. Cohen.
But thank you, Greg. So Randy, you mentioned earlier about sheriffs specifically having to, house these individuals, having to run the jails, and the pressure that puts on actually getting this correct. So let me ask you this question. We exist, and you and I have discussed multiple times, both in person and on live streams such as this, the issue of defunding the police. So in this era of defunding the police, we're talking about the pressures that this puts on the jailers, who also falls under the sheriff. Now, the sheriff, while you were municipal law enforcement, the sheriff in the majority of the country is the primary law enforcement official. So now we're talking about basically competing priorities. How does jail capacity even fit in with the national discussion that we're having now?
Yeah, that's something that we don't really discuss that much. There's so many issues surrounding defunding the police that are all of them bad, right? The lack of training, that training is one of the first things that has to be cut. I think the idea that came out of the far left with defunding was to punish the police, right, or abolish them. That was basically the goal there, right? Was to punish the police, which punishment would be. I think a lot of people, when they first said defunding, thought that we're going to get rid of police officers, or we're going to somehow cut their salaries and things like that, or that we would legitimately get rid of all law enforcement, right? That it would be abolished. That was not popular, right? Not in the general public at all. But there were a lot of jurisdictions, several jurisdictions, that did do defunding to a certain extent, where they cut the budgets. Because upwards of roughly 80% of most police departments and sheriff's departments budgets are personnel costs, there's already not a whole lot of room to play with there, right? Roughly on average, maybe 20% of the budget has expenditures that aren't already earmarked for personnel. Putting more and more people in the custody of the sheriff's jail is costly. And if we start to defund, one of the fears would be that we start to make policies or even statutes that let more people go, as Greg talked about New York, right? We just start letting more and more people go, maybe not because of the risk they pose, maybe not because of their prior offenses, but because we, as the jurisdiction, right, the sheriff's office or the municipality, just can't afford to keep them anymore. That would be a public safety failure. So it's imperative that we get this right, for a lot of reasons. It's also imperative that we have the discussion about finalizing that defunding the police is just a bad idea.
And allow me to yes and that point, because especially where it dovetails with sheriff's office and jailing, I don't think there's anybody in the criminal justice space or criminal justice reform space that would argue that jails in their current condition are basically, therapeutic environments wherein an offender can be rehabilitated and successfully re-enter society from. It is, by all intents and purposes, a short-term holding solution. And, we do try to have more rehabilitative offerings in our prisons, obviously. But again, we don't see necessarily lengths of stay long enough at the local level to justify that expense. And if we're putting further downward pressure on that cost, Randy, you're exactly right. We're only going to, see more people squeezed out through our fingers that could actually pose a threat to public safety. And that's countervailing the issue of holding people that simply are not a risk to be in society. People that don't actually pose a risk walking the streets and will, to Greg's point, show up. So Greg, I want to ask you, how do we actually determine this? I've heard a lot of talk about risk assessments. I know you and I have discussed a lot about them and how they're constructed. Give us an overview of what risk assessments are and how they are applied specifically in pretrial contexts.
No, certainly. And so a risk assessment is essentially just a fancy term for a computer program that looks at an individual's certain factors, such as the incident offense, criminal history, sometimes employment status, things like that. We can get in on good ones and bad ones, but looks at these individual factors, computes a score, weights them based upon their priorities, and it pumps out a score pretty much. And those scores fall into different little buckets. And so it goes from like low to low medium to medium high. And those are supposed to determine three things a good one should be. If someone is a failure to appear, failure to commit a new offense, and failure to commit a violent offense. And so what we want to see from a risk assessment, particularly in the pretrial system, because you have these for, putting people matched up with services while they're in prison. You have it on the back end for probation, making sure if someone has a necessary need for drug treatment or something else, they can kind of match them up with that. But with pretrial, they're actually determining if someone potentially should be given their freedom back without, or potentially be detained or have higher levels of conditions on their release. And so three things that we really want to see with those on the pretrial side is that they're objective, they're evidence-based, and that they're actually able to give the judge an actual sheet and process and not hamstring them, but just give that another tool in the toolbox for a judge to make a determination based upon the individual conditions, rather than looking at a bail schedule or just the incident offense, looking at the person for who they are that's before them. And so we really want to see those three things. And those are what the good ones look like. And they're also transparent. So they're able to show what those factors are. And so the better ones that you see, they have a very limited list of them, and they're all just objective factors and not subjective. You're not doing an interview with someone. You're not asking someone how many times they've been arrested in the last year, because obviously you're going to have disparate impacts on certain communities. You're not asking, what's their employment status or ties to the community, or all these other kind of horse sense type of things that we're actually making on pretrial determinations now. You want it to be based upon objective criteria that has shown, based upon the evidence, that this is going to continue to go up. As you get higher risk, these are the people that are actually going to be a higher risk to either fail to appear or commit offenses based upon that population. And that is something that has been done time and time again in multiple jurisdictions. Kentucky is a very good example of one, and actually certain jurisdictions in Texas and across the country that we've seen these. And so that's all a risk assessment is. It's not something to essentially replace the judge. I know in baseball, it's opening day today. There's talks about doing, a computer strike zone to remove an umpire from there. That's not what we're talking about here. We want it to be another tool in the toolbox to ensure that a judge is getting all that information. I think there's a preconceived notion most people have that a judge just gets some file when they get someone presented and it has everything in there, very nice and clean. That is not what's happening across Texas. Actually, very few times does a judge actually have the full picture. And some of the worst cases that we've seen where someone has been released on a low bond or a PR bond when they probably shouldn't have is because the judge did not have all the information. All a risk assessment would do, if we implemented that state rider in a jurisdiction, would allow for a judge to have all the information that we want them to make a determination, and then allow them, based upon their experience and history working that bench, to make a proper determination with all of it. That's simply all it is essentially taking those objective criteria, putting it down to a number that we can standardize, and allowing a judge to do what we've elected a judge to do.
So could I summarize what you just said as providing a judge or a magistrate with more information?
Yeah, that's the elevator pitch on that one, Derek. Yeah.
Excellent. And Greg, before I go back to Randy, I want to ask one more thing. You did a really good job of outlining the entire breadth of what a good risk assessment is. What does a bad one look like?
A bad one is proprietary. where they're not actually kind of showing you the playbook there. One that's not evidence-based or, weighed on the actual population itself, and one that's subjective, one that takes criteria like we were talking about on horse sense type of things, like what zip code you're from and how many arrests you've had and what's been your employment status, those types of things. Bring out disparate impacts within the criminal justice system that would be not right. And they're actually not as good as an objective risk assessment when it comes to public safety and actually determining who should be released and who's not. Some people think that when we first started coming out with these earlier iterations that you needed that type of criteria, but it's not the case. There's much better criteria that has been shown and proven, and further iterations of this have shown that. I know, Derek, you've worked a lot on risk assessments and actually implementing these and creating these algorithms. And so you know more than I do on that. But looking at objective factors that can quickly be disseminated, put into an algorithm that is open for the public to understand, open for the defendant to understand, open for counsel to understand, the prosecutor, everyone's on the same page. What are we basing this on, determining on, and ensuring that's from that population? That's what a good one looks like. One that essentially just throws all the horse sense stuff that we don't want a judge to be looking at from a pretrial determination and then into some sort of model that spits out something else is a bad risk assessment. We want one that looks at that criteria that has been proven to show if someone will commit a violent crime, will commit another offense, or failure to appear.
All right, and so I want to remind our audience here that if we'd really like them to submit any questions they might have in the comments, and we'll get to those here shortly as we continue with our discussion. We'd like to hear from you and answer any questions you might have as well. So, Randy, I gave Greg all the easy questions, so I'm going back to you. Community stability, and I mean that in the abstract. Bail and law enforcement both, I would say both, inflect themselves upon community stability. Bail specifically, insofar as if we're talking about high and low risk people potentially being out. So, as somebody that's worked in these communities across the spectrum, what do you see is the disadvantage, obviously, outside from the obvious, of having very high risk, potentially violent offenders back in the community through that first failure of bail that's possible, or keeping low risk folk out of the community because of what we've already discussed? How are these type 1 and type 2 errors in bail setting affecting communities?
I think, it's obvious to all of us that when you let high risk people out, there's a risk to the community. It's public safety is affected. There's not a whole lot of argument with that, and that's probably on its face easy to see. But you hit on something earlier where when we lock up and hold low risk people, what happens there, right? Consider that, as you said, pretrial detention is not long enough for an individual to receive treatment, even if there is underlying problems that they might benefit from. It's just not long enough, and there's not the resources to do that in pretrial detention. However, they are held long enough to really mess their life up, right? They can lose their job, they can lose their family, right? Become estranged from their family. These are all the ties that bond. These are the social contract that keeps people in a civil society functional. When you take away those ties, right? Those ties to the to institutions that are healthy for them, you set them up for really bad things going forward, and recidivism and all these other things that can happen. So I guess to answer both questions, letting people out that should be locked up is problematic on its face. There's no doubt about that, right? It's dangerous. I think the one of the most famous cases down here was the trooper Damon Allen, who was murdered by someone who shouldn't have been out of jail at the time, was out on bond. That was a failure of the system. But the failures of the system that happen on the other end, we don't see all the time. I mean, we see the end result of them, but I don't think connect those dots, that when we're locking people up that are maybe no threat to society and likely to come back to court, but just can't afford to get out, that can have a really negative impact on their life. And eventually that affects public safety, right? That can destroy the community.
All right, and we appreciate the questions that we have thus far. We're going to get to them here shortly. But Greg, I just want to ask you, before we go to audience participation, I'd really like to ask you, so what kind of proposals, I know you have an eye on Texas, what sort of proposals are we seeing discussed here currently?
Yeah, and so there are bills in both the House and Senate that are moving along right now. House Bill 20 and SB 21 are probably the most prominent that are looking at how to fix our pretrial system in Texas. Some iterations have that constitutional amendment that we were discussing to expand the types of offenses that potentially could allow for detention, so someone could not be bailed out or provided for financial bail. Others look at limiting the types of offenses that could actually get a PR bond, so they require some sort of financial condition to release. Others are looking at better training for magistrates and judges across the state, which I think is a really good thing that we should be doing, because we need to ensure that judges are trained and acting accordingly and given the best information and tools on what appropriate determinations they should be making. Others are looking at transparency. One of the things that we really have an issue with right now is actual data collection within Texas on pretrial determinations. So there's very few limited information on if an individual does fail to appear for a subsequent court case. And so when you're looking at potentially implementing a risk assessment or giving a judge all the tools that they need to determine what type of conditions to release or detain someone, we don't have all that information right now. We're not collecting at a statewide level. And so having statewide data to ensure that we're getting the right information, getting the right tools to judges is critical. And so, I think there's some things in a lot of the different proposals that could be improved when we're talking about allowing for greater mechanisms for low risk individuals to be released. Again, remember that these are people that have not convicted of any crime. And so detaining someone either because they can't afford bail or even because they are a public safety risk should be used sparingly. We're talking about taking someone's freedom away. And I think we really have to be mindful of that. So providing those mechanisms for those low risk people that aren't a threat to public safety to be released, to go back to their families, to maintain their jobs. I mean, there is abundance of research that has shown that even 72 hours in jail can have profound impacts not only on someone's instant life with their job, losing their job, potentially their kids, having family law issues in the past, but actually reoffending later on. And so it's an actual recidivism public safety issue to ensure these people are actually released when appropriate. We want to make sure that high risk people can be detained, expand those provisions to allow judges to make those. And then we also would love to see a statewide risk assessment implemented to make those determinations better. So we're connecting the release to risk rather than the release to someone's ability to pay.
Excellent. And again, the comments are still open for questions y'all might have, but I'm going to dive right in. Let's start one, right towards the top, Greg. Here's one that I think you touched on cursorily, but might want to expound on. Why is a risk assessment better than just giving the judge the defendant's criminal history?
Certainly. The reason that it's better is because it is objective. It shows it's standardized as well. And so you're not having a judge look at certain weighted factors or saying, oh, I'm just the judge that looks at this, or I'm just the judge that looks like that. It actually puts that all together within an algorithm, a model that has been tested within that population to give the best information on if someone is low, medium, high, or high risk. That doesn't mean we can have one or the other. The judge can look at the individual case and criminal history of a person and look at that. But having that objective standardized program and methodology that has shown to be proven to have a better result on pretrial. There's a study that was done by Texas A&M that showed that a jurisdiction within Texas, I believe that it was Austin compared to Tarrant, that implemented a pretrial risk assessment, had better results and was better predictive at someone being released or not and what they did on the outside. And so it is shown to be a better method to base those determinations on risk. But that is not to say that a judge can't look at someone else's criminal history, it's not one or the other. I think both can be complementary to each other. And like we said, the risk assessment has that implemented within it. And so it's not like if we implemented a statewide risk assessment, you only get the risk assessment and then shield the eyes of the judge to everything else. It's just another tool in the toolbox for that judge to make a more appropriate determination.
Excellent. And then one of the issues, and I think one of the bigger animating instances that has happened here in Texas was the slaying of Trooper Damon Allen. Now, Greg, you brought up the fact that a good risk assessment will have some form of flag, some form of designator that this individual in front of a magistrate may or may not actually present an outsized risk, say to what his instance offense might be. So Randy, let me kick this to you. Damon Allen was a state trooper routinely enforcing a traffic stop on an individual who had just recently posted bond for assaulting a public official. This was back in 2017. So is this, at least in terms of law enforcement is concerned, is this one of the more animating, I would say one of the more animating precepts to really get things right on the top end, make sure that not just worry about, are there too many folks getting out on low bonds on the low side, but also making sure we are appropriately identifying and addressing risk at the top end, Randy?
Yes, absolutely. That's one of the most animating issues in the whole debate. And it's not just the threat to law enforcement. The Damon Allen issue highlighted that, and law enforcement officers are, of course, going to be concerned with the risk that is posed by someone who is out on bond. Because remember, they don't have the information in front of them either, probably. In most instances, they don't. I'm sure Trooper Allen probably didn't know exactly who he was stopping and what that risk was. But they're also going to be concerned with what the threat to the community is, right? I mean, the people that we would like to see detained pose the highest risk to public safety, not just police officer safety, but to the public, right? To the people that the police officers are there to serve and to protect. I think that the information issue that both of you have brought up is important for the judge, right? We pay judges to be judges. That means to use their judgment in this. And they can only make a good judgment if they have all of the information. There's a reason that when you go into court as a witness, you swear to tell the truth, the whole truth, and nothing but the truth, right? Because the whole truth is very important. You can tell the truth and only tell parts of it. Just like if we only know maybe a couple of things about their criminal history, as Greg pointed out, that informs us to a certain extent, but it's very limiting, right? And asking a judge to make a decision on pretrial detention or bond when they have very limited information, really, we start, and the opposite is also true, right? If we just have the computer program alone, like Greg was saying, then we have, a strike zone that's a box and a computer can do the whole thing and there's no need for a human to be involved. But that would be completely unfair and probably not real effective either, because when you combine the two, when you have a risk assessment, right, that informs a judge on potential risk, all of the information in this person's background, and then the judge making their best, using their best discretion in what they're evaluating right before them, that's where I think we're going to have our best outcomes.
And Greg, let me ask you a two-part question on this, and it's derived from one that we have in the comments. First, I'd like to say, what sort of alternatives or what sort of complements might a local jurisdiction put in place to help reduce some of these issues with failures to appear, and even on the public safety side? What options are in the toolbox?
Yeah, certainly. And so I think there's a lot of different options there. And so you touched on failure to appears. I mean, there's GPS monitoring, there's house arrest, there's a lot of other variety of ways that we can detain someone, but still allow them to live their lives, support their families, and continue potentially, hopefully, on a better path post their involvement in the criminal justice system. So I think there's a lot of different of ways to do that, and that is a much cheaper cost to the state. So some individuals may be able to afford to pay for GPS monitoring, but other people that are indigent, potentially the state needs to foot that bill. It's a lot less expensive to put someone on an ankle monitor or keep them on house arrest or have them do daily check-ins with their supervision officer or whatever else than putting them into a jail. Jail is very, very expensive. And we need to make sure of that when we're looking at that and being good stewards to our taxpayers here. Other things, let's empower police to make determinations on during the incident at the point of the at the scene. So expanding citations in lieu of arrest. So instead of having to book someone, take a cop off the street, bring them in, write all the information. I'm sure Randy's done that a million times as an officer, and how many hours and bandwidth that takes from an individual for low-level offenses. Wouldn't it be great if we can expand current law, which allows for a little bit of this to happen, to expand that to greater, to give officers and empower them and give them the discretion to say, my job and public safety will be better if I'm able to write this person essentially a ticket for them to come to court later, rather than bringing them down, booking them, interfering with their life, interfering with my time, impacting public safety in my community because I'm off the street, and expanding that. I think that is something that definitely needs to happen in a greater expansion of more communities, and allowing sheriffs and police officers that discretion to make those determinations. They're on the front line. They understand the situation, the occurrence. We should give them more tools in the toolbox. Those are a lot of different ways to kind of limit that jail population in a safe manner, an effective manner, and a more soft on crime, hard on soft on taxpayer mechanism. Sorry, I'm getting my phrasing all confused up there.
Well, you actually hit something on the head that I don't know if we've discussed enough, is that the current system does presume a lot on local law enforcement insofar as, we don't have magistration if we don't have a booking. And so, Randy, I want to ask you, just for the purpose of clarification in this discussion, you come across somebody who's committed let's say a class B misdemeanor, or maybe even a class C misdemeanor and above. What does that arrest entail, and what sort of encumbrance as a law enforcement officer is making this arrest now on you, and how long are you off the streets for? What else does it, how else does it impinge on your time down the line, and so on?
Yeah, that's one of the things I think we don't consider is the amount of time that an officer spends on an arrest, right? That's not necessarily contingent on how serious the crime is, right? So a class C misdemeanor arrest or a low-level felony arrest may involve the same amount of time. That includes taking the person into custody, driving them back to the booking room, booking them in, which includes photographs and fingerprints, taking them before a magistrate to be bonded. This can take up a significant portion of an officer's day for very, very low-level crimes. I was a police officer in Illinois, as we discussed earlier, and when I first started, the department I worked for, we had a very large regional mall. We would get 3 or 4 retail thefts, low-level retail thefts per shift. The officer that was in charge of that beat was down almost their entire shift working on these arrests almost all the time, right? They would churn out one, have to go pick up another one and do it. One of the most efficient things we did, and I won't get into how we did by switching to local ordinance issues, was the ability to cite and release low-level crimes, and a variety of them, retail theft being one of them. That freed up so much time for our officers. It was incredible. It was now as simple as responding, writing the ticket, and then leaving. Now, we had parameters around that, right? It couldn't be a repeat offender and all of those things. So we kind of did our own little risk assessment from that end. It couldn't be over a certain amount. If it went over the felony threshold, we couldn't do it. But for the most part, most of them were lower level ones, and that freed up a whole bunch of time. That was one of the most cost-effective changes we did during my whole career, I think.
Excellent. Thank you, Randy. And Greg, I'm seeing in the comments and the questions kind of a repeating theme that I think is due to a little bit of perhaps misinformation or unclear understanding of how risk assessments work. We have several questions about bias in risk assessments or inequity in risk assessments. Can you rehash some of your, I would say, earlier answers, but packaged in a way to address that specific issue?
No, certainly. And I think we need to take it a step back within the criminal justice system. The criminal justice system currently is inherently biased and has disparate impacts on certain communities. And so let's just kind of take a 30,000 foot of where we're at right now within the criminal justice system, and how the current pretrial system sometimes exacerbates those. We're looking at an individual's ability to pay. That obviously is going to have disparate impacts on lower socioeconomic and minority communities. And so that's where we're at right now based upon the current system. And so if you're trying to remove all bias or eliminate all bias, you're just not going to be able to do that in the criminal justice system right now. Now, the goal of what we're trying to do is right size, minimize those disparate impacts, and move forward. And so actually risk assessments do minimize current biases. But if you're just looking at it from, hey, we're going to put this on and now hope that all bias is gone within the criminal justice system, you're just not going to have it, because you're going to be looking at factors like convictions and things like that. And, minority communities, urban communities are policed more often. There is much more going on in those communities where someone can get arrested and convicted of an offense. And so that is not going to change if there's a risk assessment or not. That it's just not going to change that. And so we need to look to take a step back and say where we are currently and where are we trying to get. And so inherently within, risk assessments, you're going to probably have minimal biases, but it's definitely going to be better than what we're doing if someone can afford to pay bail or not from a pretrial system. So again, we want to make sure, and that's why it's very important that the risk assessments are objective, are on factors that actually prove someone's risk of flight, potential to commit another offense or commit a violent offense, and look at those factors rather than if someone can afford to pay bail or not. That is a much better and a much more minimalist look at minimizing bias within the criminal justice system than the status quo. Now you can go the other way with it and just release everyone for certain offenses, and that's one way to go about it. But I think that's divorcing ourselves from the public safety risk as well. And so we need to find that balance right now. And a risk assessment is a great way to try to show an individual's risk, minimize bias, and have a more just pretrial system.
Excellent. Thank you for that, Greg. I do appreciate that clarity. And now the confluence of low-level offenses, bias, and the like tend to circle around the lower end of the risk spectrum, or again, at the very least, we can agree the lower end of the incident offense spectrum. And so, Randy, one of the measures you've been supportive on, outside the area of bail, has been limiting arrests for Class C misdemeanors, which, as you know, here in Texas, are our lowest level of offense. It include things like, failing to signal a lane change and other sort of traffic level offenses. Why is that, and how does that particular effort play into the discussion we're having here?
Yeah, the arrests for non-jailable offenses is a liberty issue. So at Texas Public Policy Foundation, that always comes to our forefront, and we consider that as well. You're talking about taking someone into custody, handcuffing them, bringing them in for bond, potentially holding them pre-trial for a very low level offense, right? One that even if they were convicted, they would not get jail time for, right? That's not a possible punitive measure for them. So in essence, what you're looking at is the arrest itself is significantly more punitive than what the statute allows for the state to do to the person upon conviction. And that's a huge liberty issue. So then the other end of the argument comes from, is this a genuine tool for law enforcement? Well, it's a tool in the sense that it can sometimes be a workaround of the Fourth Amendment, right? That we make an arrest for a non-jailable offense, just a traffic stop, like the example you gave was failure to use a turn signal, which is what originally got Sandra Bland arrested, right? In order to potentially find other crimes. That's sometimes you'll hear the argument come from law enforcement, not all of law enforcement, but some of it. They use the Timothy McVeigh traffic stop in Oklahoma as an example for that, right? That he was arrested for a traffic offense, and he wasn't. He was arrested for unlawfully carrying a firearm. It was just genuinely good police work that got him arrested. And I guess that's what I point to, is that kind of tool, right? That workaround from the Fourth Amendment promotes lazy policing, right? Good policing can still be done, right? You can still stop someone for not using a turn signal and still doing a very good investigation that results in a different arrest for something better. But if all you have at the end of the day is not using a turn signal, locking someone up for that just seems to run cross to what we understand as liberty. And I think genuinely, I think a lot of people don't understand that they can be physically arrested for very, very low level offenses. Not using your turn signal, expired license plates, all of these things that, we know we can get a traffic ticket for it, but I think very few people really truly understand the potential consequences to that if an officer chooses to do that, to go that route. So limiting that would promote better policing, more fair policing, and better investigations at the end of the day. I think every police officer would rather know that they took a real criminal off the street rather than somebody who just didn't use their turn signal. So it would promote better policing.
Well, thank you for that, Randy. And Greg, we just had a question that dropped into the comments that I think that both you and I were probably negligent on addressing in the past. It asks, should a risk assessment be binding for the judge to follow?
No, I don't think so. I think it needs to just be another tool in the toolbox for them to get objective evidence-based information to complement the determination they're going to make based upon their experience. Again, that is all it is just a bringing objective evidence-based information before a judge to make the best determination based upon their experience and allow them to continue to have discretion. So I think that the word that I think we're kind of missing there is that discretion. Provide judges discretion and continue to make determinations for pretrial based upon risk rather than financial ability to pay. And the risk assessment can help with that. That's not to overshadow or become, like we said, the computer umpire there. It's to give a little bit more data saying, hey, you continue to miss on the outside strike zone here. Potentially you need to modify or look at what you're saying. Just giving that information, this is all it is. It's just more information for a judge to look at, to use their discretion to make the best pretrial determinations possible.
Well, let me drill in and play devil's advocate on this. I mean, we obviously have these horror cases coming out of Harris County where people who present as dangerous are quite that. And, the tale of the tape tends to play that out. What is the downside risk of having, basically having as you said, the computer umpire calling the balls and strikes?
So what is the downside risk of having the computer calling the balls and strikes? Well, I think the problem is you're kind of handcuffing judges and not allowing them to look at the facts and circumstances of the case. I think that is the problem with potentially just allowing for that computer model to be the end all be all for things. I think it should be persuasive. I think in some circumstances, even potentially presumptive, but we need to allow for judges to look at an individual, look at all the facts and circumstances and make that best determination. I think we talked to the Office of Courts Administration. They have a risk assessment they've put together. They ran the one on the defendant in the Damon Allen case, and they said it was one of the worst that they've ever seen. And in no circumstances should he have ever been released on a bond or otherwise. But that information wasn't provided to the judge because we have so many cases in the churn. The amount of people that are arrested and put into jail and gone through the criminal justice system in Texas is staggering. Currently, right now, we have over 35,000 people in detention pre-trial for felonies. We have 4,100 pre-trial for misdemeanors. We have 4,800 pre-trial for state jail felonies. That's just the people that are in jail. We're not even talking about the people that have been released or just arrested on a site in summits. That is so many people. And so when you have such a high churn in a huge state like Texas and major jurisdictions like Harris County and Dallas and Austin and Fort Worth, you need to have some sort of standardization to look at risk and provide that information to a judge. There is no way, based upon the current system, that we can have individual determinations of defendants in a way that promotes public safety and allows for a just system where the low-level people are able to be released while the high-level people are detained. It is absolutely impossible. And so it is required that we have some sort of objective standardized assessment to bring that through.
And thank you for that, Greg. And Randy, one more thing I wanted to ask you is we've talked about, SB 237 just now. We talked about the no arrest for non-jailable offenses idea. Again, we have to come back to this issue of what are we spending our law enforcement dollars on? And I think we all share the conclusion that reducing law enforcement expenditures, specifically as we laid out for training, is a bad idea. In conferring discretionary arrest authority, or should I flip that other way, in conferring citation authority on police officers or giving them that tool in the toolbox, what sort of training needs to complement that to make sure that they are using that effectively or that they can use it to the best effect of public safety?
Yeah, that's a great question. When we come back to the idea that training is so important in law enforcement, anytime we do make any sort of changes, it's important that we address that through training as well. Law enforcement benefits from having more tools in their toolbox, whether those are legitimate tools, right? I think we've seen over the past 50 years the implementation of less lethal technologies has helped law enforcement significantly. And by helping law enforcement, I also mean that they help the community, right? There's less people that who would have found themselves on the other end of a shooting had those not been developed. the same thing goes for this, right? When we tell officers that they have the discretion to cite and release somebody rather than take them to jail, they're going to end up going through a very similar risk assessment in their own head, individualized to that person on the street. And how we would do that, some of the things that need to be taken into consideration, is this person likely to show up? Is this person likely to reoffend? Is this person likely to continue the offense that I'm stopping them for right now if I just let them go? Is the arrest going to actually fix this problem currently and address the future issues, or would I be able to do that with a citation? But having some kind of training where officers are guided in that kind of risk assessment that they're going to do, that they're going to use it. Now, it's not going to be the program that Greg's talking about. This is much simpler, but something that they can put their make the best discretion decision that they can would be helpful for them. But more tools are always better. Any police officer would tell you that having that discretion to be able to utilize that is a benefit to them.
Well, I want to thank both of our panelists today for joining us. Thank you, Randy. Thank you, Greg, for taking time out of your busy day to talk about this important issue. And while I will admit that it is April Fool's, and I look forward to watching the Detroit Tigers, the nation's preeminent April Fool's joke, later today, I really appreciate you joining us here as well while we talk about this issue, and we look forward to the progress that we make on it going forward. Thank you.